Mr. Skirek said, defense calls Mggie Sklar.
Mggie Sklar, called as a witness by the defendant, having been duly sworn, testified as follows.
The court said, "Please state your name and spell it, please."
The witness said, "Sure. My name is Maggie, Maggie Sklar."
The court said, "You may inquire."
Mr. Skirek said, thank you, Your Honor.
Direct examination. By Mr. Skirek.
Good afternoon, Ms. Sklar. Where are you presently employed?
I'm employed as a managing director at SEDA Experts, SEDA Experts. That is an expert witness consultancy firm where I provide expert witness testimony in crypto and financial markets cases. I also run my own consultancy business, Sklar Strategies, where I represent clients in the crypto industry as well as other financial markets industries.
Thank you. Now, Ms. Sklar, can you tell us a bit about your educational background, please?
I'm a graduate of Georgetown University. Georgetown is in Washington, D.C. I graduated with a BA in 2001. I also graduated from Georgetown with a law degree in 2005.
And, Ms. Sklar, have you spent any time in public service?
I have. I was in the government for about a decade. I started at the CFTC. That's the U.S. Commodity Futures Trading Commission. And the CFTC is the regulator responsible after Dodd-Frank Act for regulating a lot of financial markets called derivatives. Also, I'm sure you'll ask when we get to crypto, but a lot of focus on crypto as well. While I was there, I started as a special counsel in the Division of Market Oversight where I regulated some of the largest exchanges. I was Associate Director for International Affairs. I was also the Senior Counsel and Policy Advisor for Commissioner. And I was also the Senior Counsel and Policy Advisor for Chairman Giancarlo.
Thank you for that. And as part of your work at the CFTC, did you advise on cryptocurrency and blockchain-related issues?
I did in 2015 when I was advising for Commissioner Wet Jen at the CFTC. The CFTC was the first agency to claim some level of authority over Bitcoin. And so I advised on that matter. But I also while the Senior Counsel and Policy Advisor to Chair Giancarlo, also known as Crypto Dad, by the way. That is the title of his book. But also the title of many of memes and other things in the crypto industry that he has been associated for. And that is because while I was also working for him and advising him, he testified before Congress for the first time describing what the CFTC could do with crypto, why he was interested. And why he was interested in crypto. And importantly as well, while I was there, we approved the first regulated crypto product Bitcoin futures in the United States, as well as the world. So it gained both attention all across the United States government as well as governments all over the world.
And while you were at the CFTC, did you also advise on crypto exchange-related issues?
Yes. So the first Bitcoin futures product we advise on, but others came after that as well. As well as others not just Bitcoin, but other types of cryptocurrency.
And then did a time come when you left the CFTC?
I did. I joined the Federal Reserve in Chicago as their Senior Policy Advisor and Director of International Engagement for Financial Markets.
And while you were at the Federal Reserve, did you also advise on crypto-related issues?
I did. I did internally as well as continue to do speaking engagement externally as well on crypto.
And then following your work for the Federal Reserve, what did you do next?
I became a partner at Davis Wright Tremaine, which is a large international law firm. And I was in the banking and financial services practice.
And did a time come when you left the law firm?
I did at the end of last year to join SEDA Experts and do my own consultancy. But also in between I also was the chair of the Public Policy and Regulation Committee for the Global DCA, which is the Global Digital Asset and Cryptocurrency Association.
That's a trade association of some sort.
Yes.
Ms. Sklar, do you also have speaking engagements that you participate in?
I do. I've spoken on cryptocurrency and blockchain issues at most major industry associations, including, for example, SIFMA, which is the Securities Industry Association, as well as specifically crypto associations. Most recently just last month at the Government Blockchain Association. But also for academic institutions, I think most recently at Duke University.
Now, what is your connection to this case?
I was hired to discuss cryptocurrency and the blockchain.
Are you being compensated for your work on this matter?
I am.
And how?
I'm being compensated at an hourly rate through SADA Experts, which is the firm I work for.
And what is your hourly rate?
For this case, $14.50 an hour.
And approximately how much have your fees been as part of this matter to date?
I think around now maybe 70,000, maybe 60,000, but around there.
And has the defense team covered your costs for traveling to testify here today?
Yes, on Amtrak and staying at hotels locally, yes.
Ms. Sklar, does your compensation depend in any way on the outcome of this case?
No, it does not.
Does your compensation depend on whether you testify a certain way?
No, it does not.
Before you were engaged in this matter, had you and I worked together before?
No, we have not.
And how about any other members of the defense team, before your engagement on this matter? Had you worked with any other members of the defense team before?
I have not.
And then how about Mr. Guo? Had you ever done any work for Mr. Guo before your engagement on this case?
No, I have not.
Now, did we prepare for your testimony here today?
Yes, we've met before, yes.
And do you recall approximately how many times we met?
I think about 4 times in person and maybe 3 times on Zoom.
Now, Ms. Sklar, did you review certain materials as part of your preparation for testimony here today?
Yes, I did.
What materials did you review?
I reviewed the indictment. I reviewed the exchange's white papers. I reviewed third-party contracts related to the exchange, Armanino, Certic, BitGo. I reviewed certain testimony and I reviewed the blockchain.
Mr. Sklar said, Your Honor. The defense offers Ms. Sklar as an expert in cryptocurrency and cryptocurrency exchange blockchain issues.
Mr. Horton said, Your Honor, we have 2 discrete issues to raise at sidebar.
The court said, okay.
Continued on next page. At the sidebar.
Mr. Horton said, Thank you, Your Honor. This is an expert witness who is also a lawyer who has worked at the CFTC regulatory agency jurisdiction in this country. We'd ask, given that background, given that her subject matter is not sort of the law of crypto, but rather mechanics in the normal cryptocurrency industry, that Your Honor give a brief instruction. Instructions on the law in this case should not come from a lawyer. That will come from Your Honor. So we ask for that instruction, given this is the first lawyer witness in the case. Then there's 2 issues that come out of the path up to qualifying her.
The court said, Can I interrupt you? Are you expecting that she is going to be giving legal expert testimony?
Mr. Horton said, I don't know. But given that a part of establishing her expertise was that she's a lawyer. She went to law school, worked at regulatory agency. She got law degree from Georgetown. She was a lawyer at CFTC to commissioner at the CFTC. I think it qualifies that we're not getting instructed on the law of cryptocurrency. That will come shortly from the court. She's testifying as to something else.
The court said, So are you expecting her to testify on legal conclusions?
Mr. Sklar said, No, Your Honor. The disclosure in this case have been clear that Ms. Sklar is not being called to testify as a legal expert. She's being called to testify for her expertise into the industry.
Mr. Finkel said, Another point, Your Honor. She worked at the CFTC. She knows what is legal and isn't legal. Not specific to the law. The law will come from Your Honor, and that should be.
The court said, Could you repeat the scope of the qualification that you're asking for?
Mr. Sklar said, She's being offered as an expert in cryptocurrency. The functioning of cryptocurrency exchanges and relatedly blockchain. And I will add, because I foresee the government raising this in a moment, that she is not being offered for having conducted some forensic analysis from a sort of code software expert point of view. She's not an expert in software. She's not an expert in coding. She's being offered as an industry expert in how things work.
Mr. Finkel said, Your Honor, on that point if I may. The other day, I think last week, I raised an issue that we asked a couple of questions of defense whether she reviewed the blockchain and whether she reviewed the smart contract. And Your Honor directed defense to confer with us, and the government and defense, me and Mr. Schrick and Ms. Murray, had a very good conversation. In that conversation, we were told by Mr. Sklar she did not review and analyze the blockchain. She merely looked to see on Etherscan that there was a blockchain available. Ms. Sklar just said she reviewed the blockchain, analyzed the blockchain in this case. That's beyond the scope of her disclosure, and it's not permitted. And to the extent Mr. Sklar is going to go against what's in the disclosure, and frankly is different than what we discussed, which is really disappointing, we would have put that in our letter. We flagged a lot of issues for Your Honor. She can't testify about the blockchain or analysis she did on the blockchain, what was happening on the blockchain. 1. She's not qualified to do that, and we would object to her qualification on that issue. She's an attorney who worked on contract. And more to the point, it's not in their disclosure that she analyzed the blockchain, and we were told that she wouldn't testify to that.
Mr. Sklar said, if I could respond to that, please.
The court said, I just want to go back to what you said. You said you want me to qualify her as an expert in cryptocurrency and the functioning of cryptocurrency exchanges and relatedly blockchain. So,
Mr. Sklar said, cryptocurrency, as Your Honor well knows, operates on a blockchain. So to the extent that she needs to, I expect to ask her if she knows she can explain what a blockchain is at a high level. How it functions. We're not going to need to get into too much detail than that. It's pretty basic description of how it works. Does that answer Your Honor's question? If I may respond to Mr. Finkel's point.
The court said, go ahead.
Mr. Sklar said, I have to say, first of all, I'm a bit disappointed how that conversation was reported. I don't believe that that is how that conversation went. And I listened to you, and I'd appreciate it if you'd listen to me. I never said that she wasn't going to testify that she looked at the blockchain. In fact, I was very specific as to the disclosures in this case that have been very specific that she can use publicly available tools such as Etherscan. This was something that was an issue in briefing before Your Honor, and the motions was to preclude. We were very clear. She used publicly available resources like Etherscan to look things up on the blockchain, which is something that frankly either of us can do. It certainly helps that she has the expertise. And she is going to testify to observations that she made based on using those publicly available tools. That is the distinction. If I understood you correctly, Mr. Finkel, you were asking whether she was going to testify whether she did some forensics of all of the movements of the tokens on the blockchain. She did not do comprehensive analysis of that. But she can testify to things that she sees using publicly available resource and tools. Some of which will be whether they exist, whether the token exists, where they were at certain points when they were created. None of which is the subject or needs to be the subject of any forensic analysis.
Mr. Finkel said, I don't want to get into a back and forth about the conversation between Mr. Sklar, Ms. Murray, and myself. But that's not an accurate reflection of what Mr. Sklar told us about Ms. Sklar's testimony. And we had that conversation to avoid this one, to have to bring the issue to Your Honor. The point is that Ms. Sklar, we had understood, could say that she went on Etherscan, which is a publicly accessible tool, and saw that there is a smart contract on the blockchain. They exist. We didn't call our expert. We will on our rebuttal. He will testify there is really no activity on the blockchain. To the extent she is going to say anything more than there is a blockchain which exists, Mr. Sklar, we don't object to that fact that she saw there is a blockchain.
Mr. Sklar said, you mean the tokens on the blockchain?
Mr. Finkel said, no. There is a blockchain. If I could just finish. She cannot testify, she is not an expert on it. Number 1. Number 2, it's not disclosed she saw any transactional activity on the blockchain, or what it means or the analysis of it. That's beyond the scope of her testimony. Her testimony As we already understood, they had a contract with BitGo. They got Arminio. They have white paper. They have certificates. All that suggests it's a cryptocurrency, or whatever it's going to say. But any analysis of what's occurring on the blockchain, that's what our expert disclosed in detail what he saw on the blockchain. Ms. Sklar did not, and so that's a disclosure problem. And 2, she's a regulator. She doesn't know about blockchain. She doesn't have a chain analysis.
The court said, "Is that information publicly available, the transactions?"
Mr. Sklar said, "Yes, Your Honor."
Mr. Finkel said, "The transactional information is public, however. What it means and how it's interpreted requires expertise, and she is not suited to deliver that opinion, number 1. And more to the point, Your Honor, and this is I think the problem, it wasn't disclosed. It's not in her disclosure. So we're not prepared for it at all for her to say these movements and these transactions back and forth."
Mr. Sklar said, "Your Honor, I'm happy to refer the court to the ruling dated May 17 on Ms. Sklar's testimony. The relevant portions are highlighted here. It's a publicly available tool. It's used to review the blockchain. And Your Honor held gives them a fair opportunity. The disclosure was adequate and gives them a fair opportunity on cross."
Mr. Finkel said, "What that says is different than what Mr. Sklar just said she's going to testify about."
The court said, "Let me just read this again. So I said that clarified that publicly available information is a reference to the publicly available blockchain on which HCN and HDO were minted, which was available to view using website called EtherScan. What I understand the government to say is that she did not go into her specific observations. Am I correct?"
Mr. Finkel said, "That's exactly right. We can't go further than what the court's order says."
Mr. Sklar said, "Of course she has observations. What's the point of looking up the information on the blockchain? That's the only reason one would do that."
The court said, "So she's not here to merely state the transactions she observed. You want her to interpret what that activity means. Am I correct?"
Mr. Sklar said, "Your Honor, I believe her testimony is going to cover the fact that she looked these tokens up on EtherScan. She can tell that there was movement of the token, which is obvious using EtherScan. She can testify they were created, dates they were created. This is all information that was publicly available via EtherScan."
The court said, "It's one thing to state that the information is available publicly. You can look it up using EtherScan. It's another thing to get into the specifics of the actual transactions."
Mr. Sklar said, "She can see the transactions on the blockchain just the way that or anyone can. It's mere observation."
The court said, "That brings me back to the question that I asked. So sure, she can say what's there. But the question is her interpretation of that activity, what it means."
Mr. Sklar said, "The blockchain not only records, as Your Honor knows, static snapshots of where tokens are at a given point in time. It also reports transactions. That's the nature of it inherently, is that it records transactions. It makes them publicly available. It's no different than saying she observed transactions. So, I mean, that's the same thing. It's enabling her to say, I saw the tokens on the blockchain and observed transactions."
The court said, "What was your disclosure of your expert?"
Mr. Finkel said, "The disclosure, there are a few things sort of circling the disclosure. Our expert did an analysis of the blockchain. He traced the movement in the blockchain. He determined that according to the blockchain 99.9, I think 99% of HCN and HDO were owned by the Himalaya exchange. There's very few transactions on the blockchain. Despite the fact that HCN and HDO were according to the market capitalization, it makes it the 6th most valuable cryptocurrency." Essentially, his opinion is that the value of HCN and HDO as reported on the Himalaya exchange doesn't fit with the number of the transactions on the blockchain. Plus, the concentration of the ownership on the blockchain suggests that it's entirely controlled by the Himalaya exchange, which implies that it's not a true cryptocurrency because it's not owned by the publicly, and it's not usable by the public. To get back to sort of Miss Sklar, and the problem is twofold. One is, I hate to say this, but we were told in explicit terms that Miss Sklar would testify that she could see HCN and HEO on Etherscan. And the fact that they're available, exactly what your honors ruled as part of her opinion, we don't object to that. What we object to is what Mr. Skirek is now saying, which is different than what he told us Thursday. It's a little frustrating, and I apologize for being frustrated.
Mr. Skirek said, I share the frustration.
Mr. Finkel said, I'm glad you do. What Mr. Skirek now said is she went on the blockchain and saw transactional movement on the blockchain. That's an analysis of what's going on.
Ms. Schrofa said, no, it's not.
Mr. Finkel said, excuse me. Excuse me. Why then didn't you tell us that?
Ms. Schrofa said, he did.
Mr. Finkel said, you weren't part of the conversation.
The court said, all right. Please direct your comments to me, Ms. Schroff.
Mr. Finkel said, you don't?
The court said, Mr. Finkel, direct your comments to me.
Mr. Finkel said, I'm sorry. The fact that she is now going to analyze what she saw on the blockchain. We don't know what that analysis is. There's no opinion about it in the disclosure. The mere fact that it existed that was disclosed. What your honor wrote is disclosed, and that's fair. But going beyond that, saying she saw movement back and forth, and what that movement means, we don't know her opinion.
Mr. Skirek said, I feel, Your Honor, that this is why just one more comment to reiterate. Unlike many other kinds of records or data, a blockchain is unique in that it reflects movements that you can see moving, right? You don't need someone to interpret the blockchain when you can, let me finish. You don't need someone to interpret it in the same way because you can see movement on the blockchain. So she will offer her observations about those movements which she can see, which are publicly available, which are publicly accessible through Etherscan. There's nothing about that goes beyond the bounds of what Your Honor ruled on. Nor is there anything about that goes beyond the bounds of what our disclosures were.
Mr. Finkel said, it's not in the disclosure. That's the problem.
The court said, she's not going to say what she observed. She's going to draw a conclusion from that?
Mr. Skirek said, no, Your Honor.
The court said, what use is it to you if she can't draw a conclusion?
Mr. Skirek said, well, she doesn't need. I think we get to the conclusion that we need to without necessarily needing to rely on the kind of analysis. There's lots of ways to do that. We don't need to do the kind of analysis that their expert did.
The court said, you plan to elicit from her a series of transactions and then for you to draw the conclusion yourself?
Mr. Skirek said, no, Your Honor. Just to back up FO a second. We just got to the part where we're offering her as an expert. I haven't even asked specifics. This is all being done in the abstract, which I recognize is difficult for us and particularly for the court to analyze. I haven't asked a single question about this topic.
The court said, but he's anticipating and it sounds to me like you're going to where he thinks you're going to go.
Mr. Skirek said, I'm not sure that's true. Again, we may have a disconnect over what is publicly available, publicly accessible, and what a witness can report they observed, which is frankly, Your Honor, as far as we plan to go.
The court said, what exactly do you expect her to state?
Mr. Skirek said, I expect her to state that she used Etherscan to look up the token to confirm they were created, to see the date on which they were created, the wallets in which they were held when they were created, and the fact that both cryptocurrencies are moved at different points in time, which you can see on the blockchain, and that those facts are frankly the only facts that she needs. We don't need to get into anything else.
Mr. Finkel said, can I respond to that?
The court said yes. So my law clerks have pointed out to me that page 3 of Mr. Kamraj's letter dated April 29, 2024, paragraph D, which states, as a result of this structure, typically when a user trades cryptocurrency through a centralized exchange, that trading activity would not be reflected on the blockchain because the cryptocurrency is not actually being transferred from one wallet to another. So this does sound like there is.
Mr. Finkel said, so the concept, it is disclosed. The notion of that's an off-chain transaction, which Mr. Sklar explored extensively on Cross of Jesse Brown and Sam Roberts. That concept of what an off-chain transaction is, they're free to ask her about. Your Honor allowed them to do that. What is not disclosed, they can point it to us, if it is her analysis of movement on the blockchain she observed and what that means.
The court said, "You're distinguishing the public versus the non-public."
Mr. Finkel said, no. I'm distinguishing the concept of how blockchains work and off-chain transactions versus the actual analysis of HCN and HDO-specific blockchain. She did disclose that Ms. Sklar did disclose, and I don't contest. She can speak to the general nature of how blockchains work and the general nature of off-chain transactions. What is not disclosed is the specific transactions that she observed on HCN and HDO reported blockchains. And telling me I don't need to belabor this, but I'll just leave it at that. That's not in there. And I don't believe that defense counsel can point to something that says that it is. An analysis of what actually happened to HCN and HDO that she observed and necessarily informs her view, because if it didn't inform her view, why are they asking her? If she wants to generally speak about how blockchains work and Your Honor permits her to do that, I believe that's fine. But to go specifically to the HCN and HDO blockchain and say I saw this is the concentration of ownership and this is the movement on blockchain and that is a real cryptocurrency, it's not disclosed.
Mr. Horton said, Your Honor, with respect to this highlighted paragraph. The difference is typically an exchange has off-chain activity, like saying typically banks report customers' audits in internal ledgers. A typical factor she has from the knowledge with regulating the space. That's different from saying. And I looked at 100 terabytes of Bank of America's internal ledger. And I saw that customer John Doe did this transaction in this currency became larger. The general fact that it's her experience is regulating the exchange, they often have this kind of transaction. It's a common transaction. It's totally different from. I'm now going into a particular database and analyzing it from within.
Mr. Sklar said, last point because there's some confusion here. There aren't HCN and HDO blockchain. There is no such thing.
Mr. Horton said, they're on the Ethereum blockchain.
Mr. Finkel said, and their transactions are recorded.
Mr. Sklar said, I don't think you know this space because you wouldn't say that if you did.
Mr. Finkel said, I do, and our expert will say it. Please don't impugn my integrity.
Mr. Sklar said, there is a blockchain. This is the Ethereum blockchain, which Your Honor knows well. The question is merely using, and the blockchain is publicly available. There are ways to look at it. You don't need to have any special experience or access to information. You can do it if you know how to use it and use Etherscan. All she's done is employed those publicly available tools to look at a publicly available resources and make the observations just the same as any witness would make observations about things that happen around them or what they saw or what they heard and what they smell.
The court said, the problem that I have is she's an expert, and it would be appropriate for her to be making those observations and drawing conclusions if she had discussed that in her disclosures, and this is what I'm not seeing. I see a general statement, but I don't see the specific analysis.
Mr. Sklar said, I'm happy to go back and look at this and find the disclosure for Your Honor. I thought that the reference that Your Honor made in your opinion picks up the disclosure that this is something that's publicly available and in a viewable view in Etherscan.
The court said, that's not what I meant. I understood of course that material is publicly available, but it's different to say that she's permitted to now testify about these specifics without having first disclosed them.
Mr. Sklar said, my point, I understand the court's point. My point, Your Honor. Your opinion was based on our disclosures. That's all that the court had at the time that you wrote the opinion was our disclosures, and the government challenged our disclosures. So that's why I think the fact that it's in the opinion shows that it was disclosed. I think Your Honor quoted from our disclosures, and I'm happy to take a look. I don't have it in front of me.
The court said, if you want to point me to something that's specific, in other words, that tracks what you expect her to say today, then fine. But I think that what the government is saying is that you can't do that, that there is no search-specific information.
Mr. Skirek said, if Your Honor would indulge me to give me 2 minutes to look through.
Mr. Finkel said, Your Honor's right. I think the conflating on what we don't object, which is the general concept of how blockchains work, and the specifics of the analysis. If Mr. Skirek is telling us he's going to point to anything in disclosure, here is my analysis.
Mr. Skirek said, I just said I'm going to try to do that.
The court said, go ahead and I'll wait for you.
Mr. Skirek said, are we close to the 2:30 break? Would it make sense?
The court said, I suppose the question of how quickly you can get to that information. We have 6 minutes.
Mr. Skirek said, I'll try. Thanks.
Continued on next page. In open court, jury present.
The court said, members of the jury, it's time for our 2:30 break. We will continue at 3 o'clock. Remember, you're not to discuss the case amongst yourselves or with anyone else. Don't permit anyone to discuss the case in your presence. Don't read, watch or listen to anything from any source that touches on the subject matter of this case. Ma'am, you may step out. Don't discuss your testimony.
The law clerk said, jury exiting.
Jury not present.
The court said, counsel, if you step up again.
Continued on next page. At the sidebar.
Ms. Schrofa said, somebody seems to left our binder at the office. We are reprinting them now. And we'll have it for the court shortly.
The court said, is what you're talking about something different from what this April 29, 2024 letter?
Mr. Skirek said, I would have to go through because we have 2 disclosures. This was the supplemental disclosure.
The court said, I think it's the same. I'm looking on page 3 paragraph G, which says, that evidence that there is not substantial on-chain trading or redemption activity of a token, such as is the case with HCN and HDO, does not demonstrate that the token is not a cryptocurrency. So here she's referring to her observation of an absence of activity to draw the conclusion that does not mean that HCN and HDO are not cryptocurrencies. So there is some reference to the specific activity.
Mr. Finkel said, that one activity, yes. But what we understand from the questioning and from Mr. Skirek's answers to your inquiries at sidebar is that she did more than that. She performed an analysis on what was on the chain. She looked to see how who was being moved to who. The concentration of ownership. If they want to ask that one question that was disclosed, then they can do that. But all we're trying to do is protect what we were disclosed under Rule 16. Mr. Skirek hasn't identified any other Rule 16 disclosure to suggest that they're entitled to offer an opinion as to more. That's all.
The court said, did you want to go beyond what's stated in G?
Mr. Skirek said, I think G and 2, Roman 2.2, which is the minting.
The court said, what page are you on?
Mr. Skirek said, this is page 2.
The court said, so you are referring to. Ms. Sklar will also opine that in the cryptocurrency industry, there is a common market understanding that a cryptocurrency is digital currency that uses blockchain technology to record transactions on a distributed ledger. Cryptocurrencies are frequently created pursuant to self-executing smart contracts and are used as a store of value. She will further opine that given that HCN and HDO each were minted using smart contracts which can be seen on the public Ethereum blockchain and are purchased using fiat currency and traded, they meet the common market understanding of cryptocurrencies. Finally, Ms. Sklar will opine that they based on the white papers HCN was designed to operate as a trade-in coin and HDO was a stable coin.
Mr. Horton said, if I might address that.
The court said yes.
Mr. Horton said, we spent a lot of time in preparing for today's testimony there. There's a single opinion in paragraph 2 about something that can be seen on the blockchain. Set aside whether they're saying something can be seen means that she went and saw it and analyzed it. What she says can be seen are the smart contracts for HCN and HDO. Those are 2 discrete documents, one each. Those are the constitutional documents, so to speak, the formation documents for these tokens. Saying if you go on Etherscan you can see there was a smart contract for HCN and a smart contract for HDO. That's what we understood. That is what paragraph 2 says. That's got nothing with them saying. And then I analyzed, and here's the import of that.
Mr. Finkel said, or the analysis of the smart contract itself.
Mr. Horton said, it can be seen.
Mr. Skirek said, Your Honor, I just want to point out for the record that in.
The court said, Where are you?
Mr. Skirek said, in paragraph 5e, which may or may not be the paragraph Your Honor may have been reading from before. Yes, 5e, second sentence relating to redemptions.
The court said, For similar reasons?
Mr. Skirek said, Yes.
The court said, It starts. Furthermore, centralized cryptocurrency exchanges permit their users to redeem or convert their cryptocurrency tokens into the equivalent value in fiat currency, such as US dollars. For similar reasons, such redemptions would also not typically be reflected on the blockchain. Because even though the user is trading their token for fiat, there is no transfer of cryptocurrency between wallets. Rather, cryptocurrency remains in the exchange's wallet, and a corresponding debit is made in the user's account on the exchange's internal ledger.
Mr. Horton said, once again. That paragraph uses the word typically, as the other paragraphs do, to describe what she understands as typical features. Not of the Himalaya exchange, but of cryptocurrency exchanges writ large based on her general knowledge of the industry. Nothing in that paragraph of that particular analysis that was undertaken for purposes of her testimony. To say that typically you see future A at industry institution B, is totally different from saying. And then I went in and look, and it matches the normal typical features that I'm going to opine about.
Mr. Finkel said, She's always been an expert, and that's what she's been qualified to do, to talk about industry practices, and what she's interacted with the CFTC. We objected to that. Your Honor, but we're not revisiting Your Honor's conclusion. What we understand they're now seeking to do is an analysis of those smart contracts and of the blockchain, which is not what's disclosed. And there still hasn't been in all this time Mr. Skirek saying, no, look. This is her opinion about the blockchain. She can testify, because Your Honor ruled that she can, about, as Mr. Horton just said, how cryptocurrency exchanges typically operate, but not to take it a step further, which is. And I looked at the HCN and HDO smart contracts, or the HCN and HDO blockchain, and determined these two purported cryptocurrencies are tokens or credits, whatever phrase you want to use, act consistently with what is specifically market practice.
Mr. Skirek said, Your Honor. What's clearly disclosed here is that she used publicly available tools, as I said before, to make observations, right? To make observations about what exists and what happened. All of which I don't think, I hope anybody would argue, is beyond the ability of an expert to testify when third parties otherwise qualified to testify about observations in their industry. Right. And then we've also made clear that she's going to infer certain things from those observations and infer certain things from the lack of transaction or the absence of transaction, which is a different inference than the government wants to draw. But it's an inference nonetheless that's permissible with an expert testifying based on her own observation that again are mere observation. We don't need to be clear. We don't need her in our review to conduct the same sort of analysis. There's more than one way to skin a cat to conduct the same sort of analysis that the government's expert conduct. She can offer her view based on what she saw and based on inference from what she didn't see, and that's entirely permissible.
The court said, So my understanding is that she does not go into any specific about what she saw in the disclosures?
Mr. Skirek said, We did state, Your Honor, that she looked at the blockchain. That she reviewed and made observations about what was happening on the blockchain.
The court said, She doesn't share those observations with the government or with me.
Mr. Skirek said, It's no different than saying we showed an expert a document dated April 29, 2024. Do we need to go and say, here are all the things that are in that letter dated April 29, 2024? It's the same thing as saying she looked at the document. She looked at the blockchain. It's the equivalent.
Mr. Finkel said, the prior expert is instructive here. Mr. Dragon, I believe it was disclosed, reviewed the PPM. As part of his analysis of the PPM, he reached the opinion of the $2 billion valuation was appropriate. That's the opinion. Here there's no opinion about what her analysis was of the blockchain. As Your Honor just pointed out, she reviewed it. She looked at it. It doesn't mean we know what her opinion is. That's what Rule 16 disclosures are all about. And they still haven't pointed to exactly what Your Honor's question was. What was the observations that she had that informed her opinion to inform the government, and to inform Your Honor when Your Honor ruled on this? This is simply a disclosure issue. And it's just a question of, just to be clear, we do not object because Your Honor already ruled on it. General practices are fine. But with respect to what she reviewed specifically, and had formed an opinion on HTO and HCN smart contracts and blockchain activity, it's not the same thing.
The court said, my understanding is that the government is not challenging the conclusions that are stated in Mr. Kumraju April 29, 2024 letter. They're not saying she cannot draw these conclusions. What they're objecting to is going into a granular analysis that has not previously been disclosed. Am I correct?
Mr. Finkel said, yes.
The court said, I think that is only fair that she has to stick to what has been disclosed as opposed to what's coming up with brand new data that is not.
Mr. Sklar said, to be clear, there's no new data. I'm frankly hopeful that when we get to the specific questioning on this issue, some of this will be obviated by seeing where we take the specific questioning. I just want to be clear in the interest of being efficient and having minimal interruption. I am permitted to ask what she viewed on the blockchain using Etherscan that seems foundational. That was clearly disclosed, and in fact referred to in Your Honor's opinion.
Ms. Strofa said, an observation is different from an analysis of the observation. That's the distinction I think that the government doesn't.
Mr. Finkel said, her answer is the analysis of the observation.
Ms. Strofa said, no, it's not.
Mr. Finkel said, this is frankly a replay of what happened with Mr. Dragon. Your Honor made a pretty clear ruling of where Mr. Sklar could or could not go, and he tried to get around it. I don't think that's appropriate with another expert here. She didn't disclose it. It hasn't been disclosed. They shouldn't be able to put information the government didn't have an opportunity to prepare for in front of the jury.
The court said, they can't cross-examine her adequately if they're just getting this information for the first time.
Mr. Sklar said, they're not, Your Honor. The fact is we said use this tool to look up publicly available information. The same publicly available information that their expert looked at that. They're well aware of that. They had analysis. There is no surprise here whatsoever, Your Honor. I think at the end of the day we have clearly disclosed that she used this tool to look at what's publicly available on the blockchain. And I think everybody would agree that was disclosed, that was incorporated in Your Honor's May 17th opinion. It seems to me that should be fair game.
Mr. Horton said, the question is not whether there's new data in the world. The question is what data is in the Rule 16 disclosure, the purpose of which is to put us on notice so we can prepare for the cross-examination. This document, which was their second notice by the way. They supplemented deficient notice to provide Your Honor says that she observed particular discrete things on the blockchain. Namely, 2 smart contracts. That's what it says. That's what it said for 2 months now. We've been talking about this document for 25 minutes. And it's not clear what it means because we're still looking at it.
Ms. Strofa said, it's like talking about the number 6 train and saying there's 6 stops on the number 6 train. We're not seeking to analyze the 6 stops, but the 6 stops are completely apparent. They know the 6 stops. I know the 6 stops. What is the issue?
The court said, I think the problem is that they don't know. That's the problem.
Ms. Strofa said, the 6 stops. I think that's what Ms. Sklar is saying. It's all publicly available. Ms. Strofa said, we know they have it is because their expert has it and opine on it for us.
Mr. Finkel said, Rule 16 doesn't have an exception that if the government's expert did something and reached an entirely different conclusion than Ms. Sklar, by the way, that somehow makes it okay. There's no exception to that. We don't know what her view is. We know her view is ultimately different than our expert's view. And we know that our expert disclosed discrete aspects of what he observed and traced on the blockchain. Ms. Sklar did not disclose that.
Continued on next page. At the sidebar, continued.
The court said, yours sort of goes into specifics, correct?
Mr. Finkel said, yes.
The court said, all right. Well, it should be parallel, and I'm not going to permit you to go beyond what was disclosed. That is my ruling.
Mr. Sklar said, and I just want to be clear, Your Honor. Am I permitted to ask? Did you use Etherscan to observe the blockchain?
The court said, absolutely, because that has been disclosed.
Mr. Sklar said, okay. And what did you observe?
The court said, what I want you to do is to study what was disclosed, and you'll see from looking at Mr. Kamraju's words, what had been disclosed, and that's what you can go into, not into this granular analysis.
Mr. Sklar said, I don't think there's any granular analysis, Your Honor. I just want to make sure, when I ask. What did you observe, in a non-leading fashion? That the government's not going to jump up and object to her saying she saw them manipulated on the blockchain. Which is clearly disclosed, that she saw that. That's clearly disclosed.
The court said, one way to handle this is for you to ask leading questions that have been agreed to in advance, so that we don't get into her saying something she should not say. So why don't you come up with the leading questions between the two of you?
All counsel said, thank you, Your Honor.
Recess. In open court, jury not present.
The court said, have the parties come to a conclusion? You're winding up?
Mr. Finkel said, I think we have, but we just need 1 minute.
The court said, okay. All righty.
Ms. Schrofa said, Your Honor, may we have the witness take the stand?
The court said, sure.
Mr. Finkel said, so, Your Honor, we've agreed to 2 questions to be asked in a leading fashion. The government does not believe.
Ms. Schrofa said, excuse me. The translator cannot hear.
Mr. Finkel said, the government does not believe there needs to be follow-up to those questions in light of the discussion at the sidebar. And that's where the parties have an agreement on that concept.
The court said, well, I'll hear the questions when they're asked and decide if there can be any follow-up. I just want to remind Mr. Sklar and the witness to speak slowly, because the interpreters need to interpret.
The witness said, okay.
The court said, all right. Let's have the jurors brought back in.
Jury present.
The court said, please be seated. You may continue the inquiry.
Mr. Sklar said, thank you, Your Honor. I believe that we left off when the defense was offering Ms. Sklar as an expert. I believe, when the sidebar was called.
The court said, all righty then. Members of the jury, I am qualifying Ms. Sklar as an expert in cryptocurrency and the functioning of cryptocurrency exchanges and, relatedly, the blockchain.
Mr. Sklar said, thank you, Judge.
By Mr. Sklar.
Now, Ms. Sklar, for the benefit of the jury, let's talk a little bit about Crypto 101. What is a cryptocurrency?
A cryptocurrency is a form of digital currency in that it exists purely on the internet and online. But it is also used not just as currency but as a means of exchange, a store of value, a form of technology, and has also become its own sort of culture and philosophy about how money should be used.
Okay. And when you say it's on the internet, what is the role of the blockchain in cryptocurrency?
Right. So technically, and the technology behind cryptocurrency and what makes it different than, say, using your Visa, which also feels like it's online money, but you're really using real money through a credit card. The cryptocurrency only exists through a blockchain. So in this case, for example, or, Bitcoin, which I think people are generally familiar with. But in this case Ethereum, they're on a blockchain. So the blockchain is an online form of technology that serves as a public ledger, to explain transactions. And I guess how I would try to maybe visually explain it, if you haven't seen it. You could think of it as an Excel spreadsheet. So you have rows and columns. And one column. You're going to have what's called the hash. But just think of it as a bunch of whole letters and numbers that represent the transactions, so a bunch of data. And then next to that you'll have a whole bunch of numbers and letters that represent the from column. And next to that the to column. Also a whole bunch of numbers and letters. You'll have date. And then you'll have the amount that was transferred. And so when you think about it, from an Excel spreadsheet perspective, think about it, the way the blockchain works is you take that and, I don't know if this dates myself, but use SharePoint to your office mates, or maybe use MS Teams, you could use Google Docs. The point of why I'm using that to visually try to explain it is, it goes to a bunch of people and then everyone has to vote on it. And so everyone votes, and then that block, that chain, becomes, when everyone votes on it, permanent on the blockchain. And that continues sequentially over and over and over across the days, weeks, months. And it could be, let's say John and Joe are transacting that first block. Maybe Joe's fast enough that the next time he sells, the next block is him selling. That's not usually how it works. But, it could be just something completely different that happens. But you can see the chain. It just keeps going like this and going across, and it's publicly available to review. There were private websites as well, but that's part of the purpose of the blockchain is that you see that. But there's no names involved. It looks like letters and numbers.
Okay. Thank you. And what is the functioning of a wallet when it comes to cryptocurrency and blockchain?
Sure. So in order to know what you have on the blockchain and your crypto, if you're doing it individually, and there are other ways of doing this, too, but just to start, a wallet is, a term borrowed from just regular finance, right? You have your wallet, your money is in your wallet. In cryptocurrency, a wallet is the digital representation of that. So you have a service that has all those letters and numbers I'm mentioning that just goes across, like, it stores that value for you, so that you know what it is that you have. It's very hard to remember otherwise. It's a lot of numbers and letters.
Okay. Thank you. And what is a cryptocurrency exchange?
A centralized cryptocurrency exchange is an exchange where people come together to buy and sell cryptocurrency. The exchange is the intermediary or the body that stands in between them. So you're not directly buying and selling with someone, there is an exchange in between you, similar to, again, borrowing terms from, regular finance, how an exchange works as well, when you buy and sell stocks. You're not, buying directly from Apple when you buy Apple stock. There's someone in between you that's facilitating that transaction.
Okay. And what are some of the benefits of a centralized cryptocurrency exchange?
Well, first of all, you don't have to remember your hashtag of all these letters and numbers. That is the responsibility of a centralized exchange, to maintain that type of information. A centralized exchange also provides other types of services, usually compliance, KYC, and AML. KYC is Know Your Customer, AML, anti-money laundering. Also cybersecurity and auditing and recording functions. So that you just, similarly to when you buy or sell stock. The centralized crypto exchange also should be able to tell you what it is you bought and sold, for how much, and what date.
Okay. And now how is cryptocurrency created?
Similar to wallets and other sort of terms borrowed from traditional finance. Cryptocurrency is created by what's called minting, so just as money is minted and created, cash. Cryptocurrency is minted by creating new cryptocurrency that's put on the blockchain through what's called a smart contract. And that information is also publicly available online, on the blockchain.
Okay. And what is the role, if any, of the smart contract or code encrypting in minting? Excuse me.
Well, it shows you, it provides public access to people that want to see the code, that want to understand the code, to see whether it exists or not or how it's being minted. Not a coding expert. But you can see it online, coding experts obviously can, but it is publicly available. It's part of the how crypto culture has evolved that it's very open source in that way.
Okay. Now what is a white paper?
A white paper is a term used in crypto for, it's usually publicly available and on their website, to show what the technology is, what the purpose is, what the value proposition is, why someone should purchase that crypto. It's usually also forward-looking. So they usually start with what they think the value is at the time, but they very often typically include what their value proposition is in the future and where they see their crypto being used and why.
Okay. And is there a custom or practice in the space with respect to white papers?
Yes, they're typically put online on the website and shared, again, part of the open source culture, but also to encourage people to want to use or adopt that cryptocurrency by showing the technology and what the potential uses are. That's how people learn about it.
Okay. Now you mentioned the culture that surrounds cryptocurrency once or twice in your answers. Are you familiar with the term HODL, HODL?
Yes, it means to hold on for dear life.
And could you just explain for the benefit of the members of the jury what that means?
Sure. It's an expression used in the crypto culture online frequently as an expression of enthusiasm. And it's used both ways. It's used when the price of cryptocurrency goes up. HODL can mean to hang on because they believe the price is going up, and not to sell early. But also when the price of cryptocurrency, and if I didn't say this before, it's used across all cryptocurrencies. When the price goes down, too, it's also used as in, don't sell off right now, hold on. Because we believe this cryptocurrency has value.
Okay. And the same question with respect to the phrase, to the moon. Are you familiar with that?
Yes.
Okay. And can you explain what that is, please?
It's also an expression used in the crypto community. Also an expression of enthusiasm. I mean, the moon is, I think 239,000 miles away? Maybe some people actually believe the price of crypto will hit $239,000. But in general, it's an expression of the price going up and being enthusiastic about that price going up.
And in your experience, are those terms common in the crypto world?
Yes. And as I mentioned, they're used across all cryptocurrencies. It's not specific to any cryptocurrency.
Okay. Thank you. Now that we understand the terms a little bit better, let me ask you, why do people use cryptocurrency?
There are a couple reasons. First, I'd say enthusiasm for the technology. Second, privacy. Third, the unbanked and underbanked. And fourth, for cross-border remittances.
Okay. Maybe we'll sort of take each one of those in turn. I think the first one you said was a belief in cryptocurrency, or enthusiasm. Can you just expand on that a little bit, please?
Yeah. So the concept of cryptocurrency, of having a digital currency that doesn't exist through or for a bank is new and novel. It excites people in the industry and the people that create it and people that invest in it and believe in it. And even from the time of Bitcoin's inception until now, a lot has changed. And there's a lot of enthusiasm about it. You know, one comparison is often used to the internet. And when the internet first came out, there were some skeptics, thoughts about government regulation. But we all remember the first time we got our first email and it was an exciting moment. And so cryptocurrency is also in that moment, that it continues to evolve. And when you think about the internet, we had the internet, we had email. Now we have things that people couldn't even imagine were possible with the internet. TikTok and social media and every virtual reality and things like that. And so cryptocurrency, for enthusiasts, still has a lot of potential, and current potential.
Okay. And then I think another reason you identified as to why people would use cryptocurrency was privacy. Could you just explain that a bit more?
Sure. Cryptocurrency can be issued not from or through a bank or other intermediary. So it affords a certain level of privacy in that respect. As I mentioned, you can follow what's happening on the blockchain, but there aren't names involved, or addresses. And if you create different types of systems, ecosystems for crypto, People from the outside can't see what's happening on the inside.
Okay. And then I think a third reason you identified was access to banking. Maybe you can just explain that one a bit as well.
Sure. So underbanked refers to people that have access to bank accounts but do not have the full sort of services of a bank account. They may not be able to afford a savings account. They might not have the credit ratings to get a mortgage from their bank, for example. And unbanked are people that don't have bank accounts at all. And in the United States, there are millions of people that are unbanked and underbanked. Around the world, there are over 1 billion people unbanked. And when you count underbanked too, you're over 2 billion people. So how I think about it too is, in the United States, I take for granted that I can walk to an ATM, that my bank will be backed by the US government and have money when I go, and my bank will be backed, obviously, as well, when I go take out money. That is not the situation for a lot of people in the world. And so, but a lot of people do have cell phones, a lot of people do have access to either wireless or Wi-Fi. And so having apps that allow them to transact money, cryptocurrency, is one way for the unbanked and underbanked to transact money. It is being used in many developing countries as a way of increasing financial inclusion in that respect for people that don't have bank accounts. And, I would also point to, there are situations where people even that were banked may become unbanked. For example, in Ukraine, when Russia invaded, there were a lot of people that were not able to access ATMs. They were not able to when they went to their banks. There wasn't enough money left to be circulated around. People turned to cryptocurrency. And indeed, hundreds of millions of dollars worth of cryptocurrency has actually been sent to Ukraine to help because of the banking situation there.
Okay. Thank you for that. And then I think the last reason that you identified as to why people would use cryptocurrencies was cross-border remittances. Can you just explain that?
Sure. So somewhat relatedly to, that in other countries, also in the United States, people have access to phones, but may not have access to bank accounts. Cross-border remittances refers to, when you don't have a bank account, but you're making money, how do you? And your family that lives abroad, how do you send that money? And one way that cryptocurrency is used is because of that. Cross-border remittances through some major providers can charge 30% or more of what you're sending. And so when you're thinking about people that are unbanked or underbanked, why they're using these services, 30% of or more of what they're sending is, I think it's a large percentage for anyone. But it's particularly a large burden for people that are just trying to send what they're trying to send, which might be minimum wage or less.
Okay. Thank you for that. Now how does a sort of typical cryptocurrency, withdrawn? How does a typical cryptocurrency transaction work on a centralized exchange?
On a centralized exchange, you would either, depending on the exchange, either send US dollars to the exchange which would be converted into either crypto or other stablecoins, which I haven't defined yet. But it will be converted into whatever the token or crypto that you're buying is. Or other exchanges accept crypto for crypto, so you can put crypto into the exchange to buy other forms of crypto.
Okay. Now let's just talk about custody and custodians. What is a custodian?
A custodian is the entity or representative that holds your cryptocurrency. That could be a wallet, an exchange, or some other entity that has custodial rights to your crypto.
Okay. And is the custodian akin to a bank that holds the crypto on your behalf?
Mr. Horton said, objection to leading.
The court said, overruled. You may answer.
Sure. So by entity, we said entity. Yes, it's some party, intermediary, broker, bank. Some entity that is holding your crypto and has custodial rights over it. So that, they have custody of it. You can't physically hold cryptocurrency. So it has to go somewhere.
Okay. Now what are stablecoins?
Stablecoins are a form of cryptocurrency that are meant to be pegged or equivalent to a 1-to-1 ratio. So one stablecoin equals $1, for example.
Okay. And are there other stablecoins that could be pegged to other currencies as well?
Yes. US dollar stablecoins are the most common, but stablecoins are often also pegged to the euro. That's probably the second most common.
Okay. Now why do people use stablecoins?
There are a couple of reasons. One is just, when you think about just holding a basket of assets. Stablecoins are just another type of asset. So there, again, sort of the intention is for it to be one-to-one, so, if you think of having, your own, basket of assets, you might have stocks. Stocks go up and down, like cryptocurrencies do. Stablecoins might be more like having money in a money market. Mutual fund, which is meant to be like one-to-one, or like a savings account with a relatively low interest rate. It's something stable in your basket of assets, and it's not going to fluctuate. Next in the cryptocurrency sort of system, just how it's developed is. Stablecoins are often used when you're using cryptocurrency because of the instability in the price. When you're trying to transfer your cryptocurrency to different venues or means, it's common to transfer it to a stablecoin so you know where your money, what the dollar value is when you then try to transfer that out to somewhere else.
Okay. Now are you familiar with what, if any, outside service providers a centralized exchange may work with?
Yes.
Okay. Can you give us some examples, please?
Sure. They might use compliance providers, and that would include, or could include, AML and KYC providers, cybersecurity, outside wallet providers are also very common, and auditing services. As well as probably other services, looking at the code, for example, as well.
Okay. Thank you for that. Now moving on to the facts of this case and the specific cryptocurrencies at issue. I believe you said a few minutes ago that amongst the materials you reviewed were the white papers. Right.
Yes.
Okay. Can you provide an explanation of the white papers for HDO, please?
It explained the stablecoin and what the value proposition for it was going to be. And what it was at the time.
Okay. And based on your review of the white paper for HCN, can you just explain what your understanding is of HCN, please?
Sure. That was the exchange's cryptocurrency. And the white paper there too explained the purpose of it and the value proposition and where they expected that to go as well.
Okay. And why is it that an exchange would want both a stablecoin and a trading token?
There's, I think it makes sense when you think about then the sort of transfer, well. First of all, the difference in value, holding one that's more volatile, holding one that's more stable. So there's that, in your basket of assets. And then there's also just the transferring in and out. When you transfer your crypto to a stablecoin, you know what it is. When you try to transfer your stablecoin out or to something else, what it is that you're doing. And it's that's done. Again, the price of crypto can be volatile so, you don't. So transferring it to a stablecoin is frequently the way that people move their crypto around when they're transferring it around.
Okay. And what, if any, role does a stablecoin like HDO play in getting sort of value into a centralized exchange?
It's one way of purchasing a crypto from the exchange, from a cryptocurrency from the exchange. And then it's, the exchange can, pursuant to the white paper and how the exchange operates, how that gets used.
Okay. Fair to say it's something of an on-ramp into the exchange.
In this.
The value into the exchange.
Yes, in this case you could buy a stablecoin to, transact on the exchange.
And so one would purchase stablecoins using US dollars. And that value in US dollars would then be tradable on the exchange, fair?
Yes, that's.
Mr. Horton said, "Objection, Your Honor."
The court said, "Overruled. You may answer."
And the same.
Oh, sorry. Yeah, according to the white papers and what I've seen, yes, that was the purpose of that.
Okay. And the same question with respect to getting value out of the exchange. Did it function? Serve that function as well?
Yes, according to the white papers and the documents I've seen, that was the purpose.
Okay. Now, Ms. Sklar, did you withdrawn? I believe you testified earlier that you used something called Etherscan to make some observations about the tokens at issue here.
Yes, Etherscan is a publicly available version of the blockchain to look at the Ethereum blockchain.
Okay. And can you just explain that a little bit further for members of the jury?
Mr. Horton said, "Objection, Your Honor, in view of the sidebar, scope."
Mr. Sklar said, I'm just asking for an explanation of what Etherscan is, how it works, not what she observed here. Your Honor.
The court said, generally.
Sure. So similarly to how I explained visually, using an Excel spreadsheet example. The Etherscan website looks relatively similar. It just has columns going across with the hash, which is the identifier, has the from and the to, has the date, has the amount, and it's searchable. So you can search by token, by stablecoin, if you know the hash numbers you're looking for, the from, to. You can search it by date. It's on the internet. It's part of the way crypto and Ethereum works is that it's a public blockchain.
And is it typical for people to use Etherscan to observe the blockchain?
I think so, because it's free. I mean, there are other versions you can pay for, but, the free one is usually what people go to.
Fair enough. Okay. Now did you use the Etherscan to observe the tokens at issue here? Just yes or no?
Yes.
And did you observe a minting event for HDO?
Yes.
And by minting event, we mean when it was created.
Yes, as I explained, yes.
Okay. And did you observe a minting event for HCN on the blockchain?
Yes, I did.
Okay. And can you just briefly tell us what you observed about those minting events?
Mr. Horton said, "Objection, again, due to the sidebar."
The court said, sustained.
Did you observe on Etherscan that there were relatively few transfers of HCN and HDO?
Yes.
And was that surprising to you?
No, not for tokens that are relatively new. There's typically, when tokens start trading, there's a lot of illiquidity in the market.
Okay. Now let's just talk about the nature of the Himalaya exchange for a moment. What kind of exchange was the Himalaya exchange?
A centralized exchange.
Okay. And I believe you testified before that a centralized exchange may use a single wallet or a set of wallets.
Yes. Part of why people use a centralized exchange is because the exchange has the wallet in custody so that, again, you don't have to remember all of the numbers, all of the transactional data. The centralized exchange does that.
Okay.
And Himalaya exchange was a centralized exchange is a centralized exchange.
Okay. And from your review of the white papers for the two tokens at issue, do you have an understanding of a credit system that the Himalaya exchange used?
Yes.
And can you just explain that to the jury, please?
Their credit system was an internal system to keep track of cryptocurrency being transacted. It was called a credit system. But you could probably use any other word too. The word credit is just the word that was used. It could have been described as an internal ledger system. Other centralized exchanges do similarly have internal systems to account for crypto.
Okay. And you testified before that there were relatively few transfers that you observed using Etherscan. Is it fair to characterize those as on-chain transactions?
The ones that are available, the ones that you can view on Etherscan are publicly available. And that would be an on-chain transaction because it's publicly available on the blockchain.
Now what would you expect to see in terms of the public visibility of transactions conducted in a centralized exchange?
Internally, if there's an internal ledger, credit system, or a tokenization system, however the accounting is being termed or called internally, those transactions would be considered off-chain. They would not be on the public blockchain. But there would be an internal system within the centralized exchange to keep track.
So one would not be able to see transactions happening on the Himalaya exchange, for example, on-chain. Is that fair?
Mr. Horton said, "Objection. Compound."
Mr. Sklar said, "It's one question."
The court said, if you'll rephrase that, please.
Mr. Sklar said, "Sure. For a centralized exchange, Would you expect to see all of the transactions conducted on that exchange on the blockchain?
No, and in fact, one of the largest centralized exchanges in the world doesn't do that either.
And what exchange are you referring to?
Coinbase.
Okay. So for the Himalaya exchange, could you tell how many transactions were conducted by the exchange simply by looking at the blockchain?
No.
Mr. Horton said, objection, scope.
The court said, sustained.
The Himalaya exchange is a centralized exchange, right?
Yes.
And any reason to expect the Himalaya exchange to reflect transactions differently than any centralized exchange?
Mr. Horton said, same objection, scope.
The court said, sustained.
Okay. Have you heard of the phrase closed system when it comes to a cryptocurrency exchange?
Yes.
Okay. And what does that mean?
That the centralized exchange would be more internalizing its own crypto and functions and conducting more off-chain than on-chain. But when it needed to be on-chain would be on-chain.
Okay. And so fair to say you would expect most of the transactions to be off-chain?
For a closed system, yes.
For a closed system. Okay. Now would you consider the Himalaya exchange a closed system?
That's my understanding from the white papers, and what I've seen was the intent of it is the intent of it. Yes.
Thank you. Now, Ms. Sklar, I believe you, withdrawn. Did you review any third-party contracts that the exchange had with outside service providers?
Yes.
Okay. And can you just tell us about those briefly?
I saw CertiK, which reviewed the code, Armanino, which did the auditing, and BitGo, which was the wallet custodian.
Okay. And what significance, if any, do you draw from the exchange's use of these third-party service providers?
It's very typical, as I mentioned, to outsource certain things to third parties, and in fact, it's usually considered a best practice, particularly when you think of who they were using. Well, first of all, to outside auditors are always a best practice rather than relying on your own. And BitGo is one of the world's biggest and most well-known wallet custodians for crypto.
Okay. And how about Armanino, the auditor?
Again, you need to having a third-party audit for any type of exchange is always a best practice.
And in terms of best practices, what, if any, best practice would there be with respect to the auditing of reserves?
Well, you would look at, the bank accounts to see what their reserves were, and what mix that was, whether it was cash, US dollars, or other types of assets.
Okay. And just to be clear, because I think I may have jumped over the part about what reserves are. What are reserves?
Sure. For stablecoins, to when you have a reserve-backed stablecoin and you're trying to do one-to-one. It means do you have what's backing the stablecoin to make it one-to-one?
Okay. Now the outside service providers that you just described. Are those common service providers for a cryptocurrency exchange?
Yes.
In particular for a centralized cryptocurrency exchange?
For a centralized, yes.
Okay. Now, Ms. Sklar, based upon your review of the materials that you've described, and your expertise, did you reach any conclusion with respect to HDO and HCN?
I mean, that they were cryptocurrencies being, offered from the exchange. And they were on the blockchain.
Okay. And so your view is that HCN is a cryptocurrency that exists on the blockchain?
Yes.
And that HDO was a cryptocurrency that exists on the blockchain?
A stablecoin, yes. Form of cryptocurrency, yes.
Thank you for that. And what is the basis for that conclusion?
My review of the documents, including third-party documents we just mentioned, and my review of Etherscan and the blockchain.
Mr. Skirik said, okay. Thank you, Ms. Sklar. Your Honor, no further questions at this time.
The court said, cross-examination.
Cross-examination. By Mr. Horton.
Good afternoon, Ms. Sklar.
Good afternoon.
To learn about the Himalaya exchange, you reviewed its white papers, right?
Yes.
And those are documents that are written and issued by the exchange, is that correct?
Yes.
Did you pull those down from the exchange's website?
They're on the website, but I was also given the I also saw them through the attorneys.
And did Mr. Gua's lawyers allow you to interview any authors of these white papers?
Mr. Sklar said, objection.
The court said, overruled. You may answer.
I did not, no.
And did you in fact interview any of the authors of these white papers?
I didn't, no.
You don't know the names of the authors of these white papers, do you?
I don't, no.
And in preparing to testify today, you didn't visit the exchange's headquarters in Abu Dhabi, did you?
I did not.
You testified about your understanding of the intent of the exchange. Do I have that right?
Mr. Sklar said, objection.
The court said, overruled. You may answer.
The intent from the white papers, yes.
Those were based on what the Himalaya Exchange said its intentions were, is that correct?
Yes.
You didn't create an account at the Himalaya Exchange, did you?
No.
You didn't purchase H-coin credits, did you?
No. I don't think it would be appropriate for me to testify if I actually owned anything in Himalaya Exchange.
So just so I'm clear, you haven't personally used the Himalaya Exchange?
No.
Okay. And, just, again, so I'm clear, you didn't buy any H-dollar credits for yourself.
Mr. Sklar said, asked and answered.
The court said, sustained.
Do you have a cryptocurrency wallet, Ms. Sklar?
Yes.
Does it have Himalaya dollars in it?
No. As I said, I haven't.
Mr. Sklar said, objection. Asked and answered.
No financial, yeah.
The court said, sustained.
Mr. Horton said, I'll move on, Your Honor. There were at least 4 white papers issued by the exchange, isn't that right?
I think so.
Did you review all the white papers?
Yes.
So how many were there?
I've seen.
Mr. Sklar said, objection. Asked and answered.
The court said, overruled. You may answer.
I've seen drafts. I want to say I think there's 4, but, yeah, I saw what I was given. And there were drafts, yeah. It was more than, probably, 4.
I see. And there was at least one for H-coin and at least one for H-dollar, is that right?
Yes.
And 2 of those white papers were issued in 2021, correct?
Yes.
And another 2 were issued in 2022, is that right?
Yes.
And each of those white papers is almost 40 pages long, is that true?
Yes.
Each one.
If you represent they were 40 pages, I'll believe you. I don't have them in front of me.
Did you read them all the way through?
Yes.
More than once?
Yes.
And each one of those 4 I just mentioned is more than 12,000 words long, is that right?
Mr. Sklar said, objection.
The court said, overruled. If you know you can answer.
I don't know.
And you just testified that you read them more than once, is that right?
Yes.
And did you feel that you understood them after reading them more than once?
Yes.
You've reviewed white papers before you were hired to testify in this case, right?
Yes.
In fact, you're a lawyer, aren't you?
Yes.
You've been a lawyer for more than 15 years, isn't that right?
19, yes.
And in fact, you're a regulatory lawyer in particular, isn't that correct?
Yes.
And you used to regulate cryptocurrency exchanges, isn't that right?
Mr. Sklar said, objection. The witness.
The court said you may answer.
Mr. Sklar said, the witness didn't regulate.
The court said you may answer.
I can so, as you know, technically, cryptocurrency exchanges aren't regulated by the CFTC or the SEC right now. But regulated financial products, yes.
Ms. Sklar, you have a lot of experience reading and understanding cryptocurrency white papers. Isn't that fair to say?
Mr. Sklar said, objection. Cumulative.
Yes.
The court said you may answer.
Yes.
And in fact, You've advised clients of your own on drafting white papers, isn't that right?
I have, yes.
You said that white papers are how people learn about crypto tokens, right?
Yes.
You don't know how members of the Mountains of Spices farm learned about H-coin, do you?
I don't.
Do you know if David Dye shared the white papers with members of the UK farm?
Mr. Sklar said, objection. Your Honor, can we have a sidebar?
The court said, if you know you may answer.
I don't know.
Mr. Horton said, I just have one more question on that topic, Your Honor, right now. Do you know if any farm leader shared white papers with farm members?
Mr. Sklar said, objection, Foundation.
I don't know what that means.
The court said you may answer.
Sorry. I don't know.
Okay. You testified earlier about cryptocurrencies and credits, right?
Yes.
And I think in your words, cryptocurrency only exists through the blockchain. Do I have that right?
That's how you can tell if it's a cryptocurrency is when you can look at it on a blockchain.
And if you can't see a coin on a public ledger, you can tell it's not cryptocurrency, right?
I wouldn't characterize what I said that way, but...
Mr. Sklar said, objection.
The court said you may answer. I'm sorry.
The witness said, I'm sorry.
The court said, I spoke over you. If you'll read back the question, please.
Record read.